Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
incoming?
It'll be incoming.
I see.
It's going to be recurring. So,
What's the list? Okay.
but I'll find out.
Okay, that's fine. So you drove down this morning?
Luckily, you guys being in Central Time helps me out because I gain an hour, so I don't have to leave so early. I left at like 6 a.m.
That's not too bad.
Or, yeah, so it's not. I just lose an hour on the way back.
And
But
you're here for your appointment and the other day?
yeah, because my wife and I were closing on a new house tomorrow, so like I gotta finish up packing. Yeah.
Just send me none of those.
Yeah. Yeah, Fulton County, Kentucky, on the same type of charges.
Steve kept CCing me on the email, so I'm like, Steve, don't CC me unless they show me.
I was gonna say, I don't know why he did that, which I'm like, okay, that's fine.
Well, I mean, it's helpful because there's someone else from your office that I cover for too.
Oh yeah. Oh,
Yeah, I've covered for him.
okay.
So, I mean, we don't mind covering for you
No,
guys.
yeah.
The circuit court is now in session. The Honorable Mayor Township presiding. Please proceed.
Go to the next cycle, just email us and give us a
Given the motion, this is something I want to
Yeah.
deal with. I just, whatever. This should be a quickie.
Council, we're waiting for the, do you know where Mr. Medina is?
Last time I saw him, Your Honor, he was typing furiously in his office. We're getting ready for this morning.
We've had a long week, so
Yes, is that
you
just Your Honor?
normally wouldn't get the first cases, so as soon as he comes in, we'll do your motion and.
No worries, Your Honor. Thank you so much. I actually emailed Mr. Medina when I got into the courtroom, so hopefully he sees it.
Okay, very good. So. Mr. Rare?
Yeah, we're in the Office of
First
Statewide
up.
Prosecution. It's like a subdivision of the.
Good morning, Your Honor.
Good morning.
Judge, all I have in your docket this morning is Mr. William Elliott. He's an inmate.
This region, our cases, like the Tallahassee Bureau. This one. The region.
And Judge, if I can, just a moment, we have an agreement. Commissioner Approach.
You may. Thank you. Counsel, would you please announce the agreement?
Yes, Your Honor. 23 CF 338, violation of probation. Mr. Elliott wishes to admit the violation. He'd be adjudicated guilty. Probation would be reinstated. There would be a $150 cost assessed, and he'd be subject to random urinalysis as a condition of the reinstated probation.
Is that a new condition, the random UAs?
It is, Judge.
Okay. Very good. State? States an agreement?
Yes, Your Honor, that is the state's agreement, and there are some things that were already in place that he's going back to Master Toastman Industry, so he needs to complete the original requirements also.
Correct.
But that's the reason for the state making this.
Right, and if we want to note for the record, he will have to complete the original requirements. Random year analysis is in addition to those requirements.
So just want to make sure, it doesn't say in all, it says reinstate probation, but that implies with it and all the other requirements that are in that original probation. Do you understand that?
I do, Your Honor.
Let me go ahead and, would you raise your right hand? Let me swear you in. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay. So you heard your attorney state it's pretty straightforward agreement that you have with the state, but this will be a final resolution of this violation. You understand that?
Yes,
You do have the right to contest all this and go to a hearing. You're waiving that right. Do you understand that?
Yes, sir.
Believe it's in your best interest?
Yes, sir.
Okay. Based upon that, the court will accept your plea. There'll be an admission of the VOP, be adjudicated guilty and reinstate probation with all its terms, and then $150 cost, random UAs.
Thank you, sir.
And that's all I have, Judge.
Yes,
Thank
sir.
you.
Good luck.
Can I get the copy?
When you're released, we can talk.
Is this you?
I believe so.
Did you write this? I can't read it.
I can't either. I'm sorry.
That's all right. I just wanted to make sure. I was gonna ask the clerk if she could read.
Let's sign this quick. Reinstated. Your Honor, this is a VOP. This is before the court. It's Mr. James Grimball, case number 23 CF 377. Your Honor, he will be admitting to the violation with the following terms and conditions. He will be adjudicated guilty. He will be reinstated to probation to the original terms and conditions with an additional 24 hours of community service. May I approach?
Annie,
You're
how do you pronounce your last name? Is it Grimble?
Grimble, yes, sir.
Mr. Grimble, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So is it stated in agreement? Yes?
That's correct, Judge.
Okay. Sir, you just heard your attorney state the terms of the plea agreement, pretty straightforward. Adjudication of guilt, reinstate the original terms and condition, and you have the additional 24 hours of community service. Is that what your understanding of the agreement is? I see you've signed this plea agreement.
Yes, sir.
Is that your understanding? And you understand that by doing this, you're waiving some rights to go to a trial and to contest all this? So this
Yes,
will be a
sir.
final adjudication. Believe this is in your best interest?
Yes, sir.
Okay, nobody twisted your arm to
No,
get
sir.
you.
No, sir.
Court will accept the plea agreement. There'll be an adjudication of guilt, reinstate the original terms and conditions, and add the 24 hours of additional community service.
Thanks, sir.
Good luck. Thank you.
I'm sorry, Judge.
That's all right.
Scott Wiley Altilio, A-L-T-I-L-I-O, Altilio, sir, 23 CF 590. He's here present.
Very good.
Your Honor, this is going to be a plea. Your Honor, it's going to be a plea to 3 misdemeanors. Count 1, criminal mischief misdemeanor. Count 2, battery misdemeanor. Count 3, DUI misdemeanor. He will be adjudicated guilty on all 3 counts, on all 3 misdemeanors. 1 year probation on count 1, sorry, and 1 year probation on count 2 for a total of 2 years probation. Count 3 is 1 year probation, however, that's to run concurrent with counts 1 and 2. No restitution. He would have to complete a substance abuse evaluation and any treatment deemed recommended, 50 hours of community service work, no contact with the victim, anger management for the DUI, first offender DUI, school sanctions. Your Honor, he would have a 6-month DL suspension. DUI school, 1 session of the victim impact panel, 10-day vehicle impounds. He would have to complete 50 hours of community service work, Your Honor, additional to his plea. Anger management. Probation may terminate in 1 year if all conditions are met. $615 in court costs. May I approach?
When you do these, if at all possible, I know sometimes we're completing these at the last minute. If you get an extra copy, it really helps me.
Yes, sir.
To track you while you're saying it, make sure that
I will.
I understand exactly what it is. Just makes it.
I will, I
Makes
promise.
it hard. Okay. So, Mr. Altilio, how do you pronounce it?
Altilio.
Would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Okay. So, one question I have, we've got 3 TR cases that are also listed on the docket. How,
I don't know how to do that, Your Honor. I've never done it in felony court. Could we merge and dismiss them?
Your Honor, the state will merge and dismiss it.
okay. We gotta add those.
I'm sorry?
Add that
Can
in.
can you just list those? Do you have the numbers? I've got the numbers if you need to. That's all right.
I have one.
So, Mr. Altilio, did I swear you in?
Yes, sir.
Starting off slow here this morning.
It's all right.
So you heard your attorney state the terms of the plea agreement.
Yes, sir.
One addition is you've got 3 traffic tickets, and the state's agreeing to dismiss those along with the rest as part of this plea agreement, okay?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and those terms are also included, obviously, in the written plea agreement that you have, you've signed. Have you read through this thing closely to make sure you understand what it's all about?
Yes, sir, I have.
Gone over it in detail with your attorney?
Yes, sir.
Okay, and you understand that you're waiving the right to go to a hearing on this. You have the right to go to a hearing, contest this violation of probation, and have a hearing on it. You're waiving that so you can have a final adjudication. Do you understand that?
Yes, sir.
Is that what you want to do here today?
Yes, sir, it is.
Very good. Based upon that testimony, the court will accept your plea. And I'm going to try and go through this on the sentencing, Mr. Kettling. If I get any of this wrong,
Yes, sir, I'll speak up.
let me know. So you're being adjudicated guilty on all 3 counts. They're all 3 misdemeanor counts. I can't read your writing.
I'm sorry. What should I do, Judge?
So there's, well, explain it to me again. You've got 1 year what's the core of it? You have 1 year probation.
1 year probation on count 1, additional 1 year probation on count 2 for a total of 2 years probation. Count 3 is another year of probation to run concurrent with counts 1 and 2.
Okay. So it's essentially 3 years of probation stacked,
3 years of probation,
but it's only
It's
for
really
a total
2.
time of 2 years.
correct.
You understand that?
Yes, sir, I do.
And you can't terminate early. There's some other,
He may terminate early, Your Honor, after 1 year.
correct. Assuming everything has been followed, no violations, right?
Correct.
Okay. In addition, you have some other 6 months driver's license, some fees and costs, DUI school, et cetera, that are all part of this. Everything's contained in this. You understand that?
Yes, sir.
Okay. Any questions?
No, sir.
Thank you very much. That's why it's good. If I'm tracking it as you're reading it, I can make sure to translate it when I sentence.
Judge, I apologize. I'm gonna have somebody else write it off next time.
Yeah, well, it's better than it is now, you know, the kids that are coming out of high school now are not taught cursive writing, you know,
Yes, sir.
at all. They block write, it's all, that's the only thing they know how to do. Pretty amazing to me.
I'll
I'm
take
sorry.
care of it. Thank you, Judge.
Okay, thank you, sir.
Sir, I need to get your fingerprints, sir. Thank you.
And you do have 30 days to appeal this, sir. Mr. Medina, I
Just to prove that you're the
Yes,
believe
sir.
you've got
We could do.
something with one of our out-of-state state
Yes, Your Honor.
attorneys.
Steve Medina, on behalf of the public defender in reference to brickage, BRICAGE is the way it is in the Florida docket, Vasile S. 22 CF 2228. Does the court have the docket number, or do I need to get that?
It is 22 CF 2228.
Yes, and it's 30 on the docket.
Correct.
Your Honor, after the public defender filed its motion to relieve the public defender, I continued efforts to find and get an application from the defendant, and there was I think it's in the record, there was a misspelling or a different spelling of the last name in Fulton County, Kentucky. On November 13th, I got a partially filled out application for the public defender. Under the statute, the public defender, until we have a clerk-approved application, really can't do much more than try to get the application filled out. And we're allowed to work with other agencies and officials, so I've been working with Fulton County. And so I got a partially, unfortunately I said it really has to be completely filled out, but it wasn't completely filled out. It had information missing that I know from experience would cause a rejection. So I tried on November 8th to get I tried on November 16th and December 7th, and then I talked to the jail again today, and I had a very nice conversation with Miss Ashley Johnson at the jail, who's been the coordinator there with me on these issues. She expects to talk to him today. I don't know if he has a Kentucky appearance today, but she's optimistic that he will complete the public defender's application. Based on the partial information I have, I anticipate that the public defender will be approved by the clerk of the court. So if we could defer to another day the motion that is before the court today, and basically status-wise, just set it off for maybe 2 or 3 weeks, something like that, and I should have it, the complete application, and hopefully it'll be approved by the clerk. That will then,
Help me out a little bit here.
yeah,
I was reading through this, and I'm not, what's this, why are we even here? I'm a little bit unclear about what is the state's interest in trying to remove the public defender in this case?
no, that was not the state's motion, Your Honor.
Okay.
That was the public defender's motion.
Because you didn't get the paperwork. I thought they were talking about the fact that you wouldn't cooperate in a universal settlement.
No, Your Honor, and just to clarify, and for the record, Guillermo Vallejo on behalf of the Office of Statewide Prosecution, and frankly, the state really has no dog in this fight other than comporting to the statutes and the recent case law with the first DCA, but basically after...
Well, we all kind of have that same kind of...
Yes, Your Honor.
That's all of our goal, is to follow the law.
Yes, Your Honor.
I just want you to be clear, I'm
No,
totally in agreement that we want to follow the law.
No, and I didn't mean to suggest anything otherwise regarding this court or Mr. Medina.
No.
But after Mr. Medina filed the motion to relieve the Office of the Public Defender, and just because I was made aware of recent case law from the first DCA, I filed a motion in opposition, simply not to say that they have to keep it, just to say that unless and until the statutory requirements of a conflict, which would either be a conflict of interest or whether Mr. Brickage does not qualify, then that is fine. If he does not qualify, then obviously it is within the province of the court to relieve the public defender. But the state's only argument is unless and until those legal requirements are fulfilled, there really is no ground to relieve the public defender. And as far as any plea offers or anything, the only thing the state referenced in its amended response was also that since there, and I won't get into the details, since there was a non-trial resolution offered, the state just wanted to make sure that that was conveyed to Mr. Brickage. And I know that he is in Kentucky, but his whereabouts are now known. And I do appreciate Mr. Medina's efforts that I didn't know until this morning that he has been in conversation with the Kentucky jail trying to get that indigency. So again, the state has no objection to reset this until that application is filled out and we kind of know where things stand.
I still don't understand why, I'm just interested, I'm not, it sounds like a criticism, I'm not.
No, that's fine.
It's like, you guys, did you come over here from Tallahassee?
Yeah, yes, sir.
You came here from Tallahassee to deal with whether or not a public defender would be appointed on this case? I'm just like, what am I missing?
No, Your Honor, and I
understand you say, well, I'm here because we're supposed to follow the law. Okay, what does that mean? I'm just interested, what do you got, what is this?
No, Your Honor.
Can somebody tell me why we're using the court's time I mean, we deal with this all day long, whether it's transition, whether you have a full application. Why is the state coming over, the statewide prosecutor versus our local? I'm just, what am I missing here? Is there a back channel fight between the public defender? Or what's going on? I just want to know. I'm not, it sounds like I'm mad because I raised my voice.
Your Honor, in this.
Am I missing something?
Could I
Sure.
follow up? Because I want to be fair to my colleague over here from Tallahassee. Basically, as I understand it, the Special Prosecutor's Office has a big RICO case, what it considers to be a big state RICO case. I am not intending to go to the westernmost county in Kentucky without an approved public defender application by the clerk of the court, because we're not supposed to be working for the person substantively. There are narrow exceptions such as bond and so forth where there's a provisional temporary responsibility from the court. But unless the court specifically, first off, the clerk of the court approves this by statute.
You answered my question.
Yeah.
Okay, so what is the crux of your motion? He's saying basically he was waiting until now I'm interested in just learning as much as I can about this whole issue of appointment. Now that we've got two learned people that have engaged this.
And Your Honor, there may be a sensitive matter we need to approach on.
Guys, if you need to approach, you can. Was it your contention? Their contention is until we get an approved, application, which we deal with all the time.
Yes.
Then we're only transitionally appointed. We're not fully appointed, whatever. What is the position of the state as opposed to that? Do they disagree with that position? Because we deal with that every day, and that's why I'm trying to understand whether going forward I do want to follow the law.
No, not at all, Your Honor. And just again, in terms of the timeline, when this case was first filed by my office, I reached out to Mr. Medina when I saw on the docket that he was appointed by the Public Defender's Office to represent Mr. Brickage, and I sent him discovery, score sheet, so on and so forth. And then at that time, I discussed, and not to get into sensitive matters, the possibility of a non-trial global resolution for his cases. Shortly thereafter, I was informed that he was going to seek the relieving of his office, And at that point, again, and this is a situation, frankly, that I just had recently read 2 cases from the first DCA on this issue of when they could be relieved, and it was kind of fresh in my mind. And my intention was not to cause this court to kind of stop everything and address this, but like from my reading of that case law, like it wasn't sufficient at that time. And again, we're not saying that they cannot be provisionally appointed. We're not saying that if he doesn't qualify, that obviously he goes. So the state's only position was, well, at this point, there's not enough to warrant them being relieved from the case. And again, I just found out this morning about the attempts to reach out.
Do you have a copy of the DCA case that you're referencing?
I don't have a copy with me, Your Honor. I did cite it in my response.
Okay.
But again,
you're not used to practicing, I like to actually
yes.
see the, if not, I'm having to rely on your interpretation of it.
Yes.
Your Honor, it's,
Anyway, we're fine.
it's not precisely a point, but Your Honor, may I just suggest that it be put out for a status conference sometime in January. By
I'm
then,
good.
we'll probably have a complete application. If the state wants to come over at that time and argue that I'm not doing a good job by not going to Fulton County on my way to Branson or
You don't have to waste
whatever.
your time driving all the way over here to attend another 10-minute hearing.
No, yes.
Well, we enjoy having you over here,
No,
It's a pleasure.
It was a nice drive. And again,
Yeah, it's a very nice drive.
I was not alleging that Mr. Medina was not doing his job at any point. And
no.
obviously, we do not object to a reset. And frankly, it will be a fait accompli that obviously once we get the full application, we'll know one way or the other. So there's there will be no need for me to come back for that issue once the application has been completed.
If
You want to come back on a miscellaneous in
or
January?
that it could be just put out on a February 14 pre-trial, and then who knows? Maybe he gets done in Kentucky.
Is he scheduled for the next pre-trial?
He's not currently, Your Honor, because we didn't really have one because he got picked up by Kentucky.
He was scheduled yesterday and today we're going to address it.
So I'm fine with doing it on 2/14.
And then by 2/14, we may have some information, and I will have to advise my supervisor what to do, because we have a lot of cases with clients in Okaloosa County Jail. It's not customary for me to have any kind of a RICO case, much less a case that I just, there would have to be massive amount of work and discovery because it's a multi-county Florida RICO case on a client who's not here for me to discuss matters with. Yeah, I wouldn't ordinarily put that on the front of the burner.
That's a whole other issue.
Right.
What is your obligation?
Right. So I would seek guidance from my elected official, ultimately, who's the one under the law who makes calls for what I do. It's subject to the court's direction.
Well, obviously, the state has some interest. Drive their attorney all the way over to Tallahassee for a hearing like this.
Yes, sir.
Anyway, we'll come back for our regular pretrial. That'll be February 14th. That's just the regular cycle. Our dock start 9 o'clock. We'll try and get this one up first. If you do happen to come over and we'll try and get it out of the way first like we're doing here. So you
I appreciate that, Your Honor, very much.
And we'll work courteously to try to avoid inconvenience and get matters moving if we can.
I'm gonna go back and look at that just because, now you've kind of understood what's going on. We've had a long week and I looked at this, but I didn't do my independent research at all, which made it fairly obvious.
No, yeah, and I do appreciate Mr. Medina's efforts, and it was not the state's intent to have a hearing for no reason or to waste this court's time.
Mr. Medina is very conscientious, so, as I see that you are as well. Okay, great. Good luck. We'll come back on February 14th if necessary. If not,
all right. I don't think.
Thank you for coming over.
Well, thank you so much, Your Honor. Have a good day.
You're welcome. Okay. Mr. Nopes, you want to?
Yes, sir. Judge, so I don't forget it, Mr. Shaw asked me to cover Jaden Bartley.
Okay.
He had already filed, I believe, the denial. What he wants to do is continue the denial and ask for the VOCC evidentiary to be January or February.
Okay, are you wanting to keep it without subpoena, not to schedule a hearing?
Yeah, he didn't say with subpoena, so I'm assuming.
He just needs to come back. We'll come back on January 16th for miscellaneous in the morning, 9 a.m. I assume at that time he's either going to have an agreement or we'll be kind of talking about a hearing.
And Mr. Notes, if we could just let Mr. Shaw know that he should have the order sheet and the score sheet. So if he, when he's talking.
So you've already provided him the offer, so if he doesn't, have him give her a call.
I will. And then, Judge, I've got Jaden Brooks for a bond hearing.
Approaching.
Okay, we're over here. Judge, Mr. Brooks's case, I believe my motion speaks for itself, but on the one robbery case, he's got $1 million bond, and that's kind of a problem. His family, I've spoke with them, and they just simply don't have that kind of money. I don't believe that that Mr. Brooks, as far as I can tell, has never failed to appear previously in court. He's lived here the vast majority of his life. His grandfather is a minister in the Crestview area. I also filed an identical motion in his other case number. This is 23 CF 1974, and I filed the same motion in 23 CF 1973.
Is that on for today?
Judge, I noticed it for today, and I filed the motion, but it is not on the docket. He's got 3 charges in that case that add up to $5,000 on the first one, $3,500, so that's $8,500, and $1,000 on the final count 3, so it's $9,500.
That's on 1973.
Yes, sir.
Your Honor, the state's argument's the same on both bonds, so the state can be prepared to do it.
What's the state's response?
So, Your Honor, in the 1974 case, I'm sorry.
What's the total on the 1973 case? The total?
$9,500 for all 3 counts.
Yes, Your Honor, that does look accurate. Your Honor, in the 1974 case, Mr. Brooks is charged with a very serious robbery charge. The allegations are that Mr. Brooks and another co-defendant were the ones who actually went into this tobacco store. It's alleged that Mr. Brooks is actually the one that held the victim at gunpoint while the products were taken by the other co-defendant. And then a third co-defendant drove them both away from the scene. Your Honor, the state does oppose a bond does oppose a bond reduction in that case, and would request that the court leave it the same. That's a very serious accusation, Your Honor, and I don't know that there are any.
$1 million bond?
On the robbery case?
Yes, Your Honor, on the robbery case, yes. It's just a very serious charge that does allege violence, and I do believe that the community's safety is at stake because of that occurrence, Your Honor. Firearms are a very serious business. And also in the other case, he has another charge of burglary, fraudulent use of a credit card, and petty theft. In that case, the victim's car was burglarized and the credit card was used. So clearly there's a pattern of theft. And then in the robbery charge, there's also there's also violence alleged. So the state doesn't believe there are any conditions of bond that are gonna adequately address public safety.
Judge, the court had a bond hearing on the co-defendant's case. It's Jaden Grant. You had a bond hearing, or there was a bond hearing held on November 14th, and I guess the court granted their motion and lowered the bonds on both of his cases, that were count 1 and count 2.
What did they lower? What did the court?
Lowered to $5,000 cash professional on count 1, which is grand theft, and count 2 was lowered to $100,000 cash professional, which
what was the original?
I knew you were going to ask me that. The original one was, Judge, I did not print that off.
State have any?
What was the original bonds on Mr. Grant?
If you'll give me just a second, Your Honor, I think they might have been the same or similar as Mr. Brooks's, but if you'll give me just a second, I will. Sorry, Your Honor, I'm trying to find the first appearance paper. Yes, originally, Mr. Grant had a $1 million bond also on the robbery charge. And the court on November 14th elected to reduce that bond to $100,000 cash or professional. But again, Your Honor, this, the state's argument for not reducing Mr. Brooks's bond is that Mr. Brooks is alleged to be the one that actually pointed the firearm at the owner of this business. So, you know, in Mr. Grant's case, he did participate in the robbery, but there's no violence alleged. Mr. Brooks is alleged to be the one using the firearm.
Sure, no, I'll give you the last word.
Judge, I guess I never expected the state to make that argument, because if they were trying him in front of a jury, they'd say that Mr. Grant was just as liable as a person that he was charged with. But anyway, Judge, I just think $1 million is, I mean, these people, his grandfather is very, very concerned and very much wants to be involved to help get things going in the right directions. But at this point, I just don't think this bond is reasonable.
Well, I certainly appreciate his grandfather's position. I also am sensitive to the state's position. I will say, and I'm not making some like big statement by saying this, but the state wants to know bond, and they need to know bond and do a formal motion. But these are very serious. I'm going to reduce it, but I'm only going to reduce it to $500,000.
Okay.
When you're it's a game changer. And I agree with the state a little bit. It's a little bit of a game changer. The gun makes it a game changer. When you're pointing the gun at somebody in the commission of a robbery, everybody needs to know that the system takes that real serious.
Yes, sir. I'll let your grandfather know.
And so the court's not going to lower it on the other case because it's only 95.
Yes, sir. Judge, I also have Keith Golden here for a bond hearing. Judge, Mr. Golden has 2 cases. You can step here. He's got failure to register every 6 months allegation. That's a new case. Then he's got 2021 CF 2522, which is a violation of probation. as a result of the new arrest. Judge, the facts of this case are a bit interesting. He is compliant with checking in with probation on a regular basis. He was even contacted around the end of October, and I guess his probation officer changed at some point at that period. He had one lady who, there was no problem with the communication and things happening appropriately and on time. And then he had a new probation officer, but there was some contact with probation on or around the 31st of October, Halloween, just to say, hey, you know, Halloween, you can't be out trick-or-treating around kids, basically. He then went to, he realized he had not registered by the end of November, and so he went and registered again on the next day, and
Next day being?
The 1st of November.
Okay, but you said he hadn't registered by the end of November.
He had not registered by the end of October.
Okay.
That was the end of his 6 months.
He was required to register.
By the end of October.
And their calling prompted him to say, oh, God, I didn't register, and he went in the next day and registered.
Right, and actually, the document, when I read the probation report, they said he registered at 8 p.m. I talked to his father either yesterday or the day before yesterday, and they actually went in at 3 o'clock-ish, and there was a problem. They called him back. They went back and redid whatever they had to do to make sure it was a valid registration. So, Judge, I'm asking for a bond. I think he's got a $5,000 bond on the new charge, and he has a no bond on the VOP, but you know, I don't necessarily think it was a willful violation. I mean, the other issue he's got is that he is on Social Security disability because he, believe it or not, he's not an old person, but he's been diagnosed with some dementia problems at an early age, and the father has asked probation, try to communicate with him too, because he lives with Dad. Y'all communicate with me, and I'll make sure everything's all right, because he sometimes doesn't remember everything. So in any event, we're asking that you set a bond on the VOP. I would ask that you lower the bond on there.
So his disability is dementia. That's the disability that's identified.
Yes, sir. That's my understanding from his father. And his father's here, I believe.
State?
Your Honor.
So what are you asking for? So on the VOP is no bonded, obviously, not obviously, because it's the VOP, you can't. And then the other one?
Is a $5,000 cash or professional bond. I just simply ask that the court consider letting that be a signature. I mean, he's got a bond on that one, so it's not the end of the world to have to post that bond. But the no bond on the VOP is keeping him in jail.
Your Honor, the state is opposed to granting bond and the reduction of bond. Considering the original offense in 21 CF 2522, which was transmission of harmful material to a minor, the defendant had the entire month of October to register, and he was only convicted of the underlying offense in June of 2023.
Sorry, say that again?
He had the entire month of October to register. He was aware that he had to register in his birth month.
Right.
And he was convicted of the underlying offense in June of 2023 in this court. The defendant had signed 3 FDLE sex offense registration forms acknowledging his understanding of the mandatory requirements. And to reference the alleged dementia, the state has no documentation of that or no proof that was shown to us. The state would also like to mention that
Would that make a difference?
I don't think so at this point, Your Honor. The
It
defendant
doesn't
also...
matter. We don't want, we're not going to, no sense in delaying this and letting him get proof of that.
The defendant also failed a drug test, which was a technical violation in September, which was only approximately 2 or 3 months following his probation. And it just exhibits a lack of respect for the court's authority, and considering the underlying offense, he is a danger to the community.
Judge, there was a technical violation. The letter was sent, and it's my understanding that I don't believe the court chose to issue a warrant for it. It was marijuana.
Your Honor, I would also like to mention, if the court does grant bond, that the required GPS is ordered for pretrial services.
Well, I mean, he is gonna have to, address the violation. But I think, considering all the circumstances, even though the court is not required to post bond in BOP, we all know that. The court does have discretion. I think in this case, all things being considered, I think there should be a bond. And it'll be a $5,000 cash or professional. I'm gonna leave the other one. So the BOP, both of them will be $5,000 cash or professional. And the court will grant the state's request for a GPS.
Very good. Thank you, Judge.
So
I didn't understand the question.
the clerk just said that they have not filed the BOP.
Judge, that's interesting. She's right. The BOP affidavit was filed, but I don't.
How was he arrested if there wasn't?
Well, so when the new case happened, it goes to first appearance, and at first appearance, there was a finding that he was on probation, and so they say you also got a BOP charge you're dealing with. That's called the probable cause BOP arrest.
Right.
And I actually need the court to say, so the notes are clear, as to the probable cause BOP arrest, or otherwise the jail will say, well, he still doesn't have a bond on that BOP.
And Your Honor, I think for Mr. Evans, in my experience, I've seen this several times, is the first appearance judge just simply fill out a form order commanding arrest, and it almost always ends up in miscommunication between the clerk's office and the jail on whether that's been served or not served.
Yeah, I don't know. In this case, I don't know that I saw the form you're talking about even being filed in this case number.
State, has there been a BOP filed?
I'm checking right now, Your Honor.
And if there isn't, how do we deal with that?
Well, so
I
again,
mean, technically, he hasn't been, there's BOP arrest.
I dealt with this several months ago, and the jail's position is that in that case, there had been a BOP probable cause arrest that law enforcement says he's on probation. That's enough for the first appearance judge to say, well, that's a charge. In my other case, the guy then got served about 10 days later with the actual BOP warrant, and the jail said he doesn't have a bond on the BOPs, even though Judge Brown signed an order saying he did have a bond on the BOP. It's really confusing. So,
How do we need to make sure that, do we need to do anything at this point?
I think the clerk's notes just need to simply say that the BOP in that case number is a probable cause BOP arrest, and that the bond is set at $5,000 cash or professional. Now, should probation file the warrant and you sign it, you can set a bond on it, but that just puts it on somebody else to remind the court when you review that,
Right.
that you've already agreed that there was a bond set on this case.
Does probation have any input? Thank you for.
Yes, Your Honor. 21 CF 2522, there is a violation of probation and an affidavit of violation of probation filed.
The affidavit was filed, but was the order filed?
No warrant was, well, let me say this, no warrant was in the clerk's office. They may be preparing a warrant, I don't know.
The violation report lists that it was for a warrantless arrest conducted.
Okay.
Your Honor, I think Mr. Nopes is right. We just need to make a note in the file. Globally, the reason we started doing this was because the first appearance judges didn't like doing a quote-unquote BOP hold for the 7 days. They get out and they come back to the jail.
Right.
And so this was a workaround, but it's got issues as the court has seen.
Right. So if we just make notes that this is for the VOP, whether it's for the warrantless or for a later, or that the actual, if there is a VOP actually filed, then this, bond is designed to apply to either or both of those.
As long as the clerk's minutes say that, I think the jail will respond to it appropriately.
I specifically wrote bond is for viewing the probable cause arrest.
Right.
And all the other conditions.
Then could your note say that in the event that probation files the VOP warrant and he served, the bond on that is also $5,000 cash protection?
Well, it would be the same bond.
It'd be concurrent, right?
Yeah, the same bond.
That, or we could do an order that might clear everything up. They could do
Is the
some
state
more
planning on
marketing.
filing VOP? I assume you are.
Yes, Your Honor.
Well,
Judge.
maybe you should make note of it that it's already been, the bond has already been set on.
Yes, sir.
So I would ask that you would kind of make sure that, and that coupled with the clerk, hopefully will avoid the confusion. Yes, sir.
Your Honor, I checked with the jail website, they did charge them with violation of probation, so when they are charged with violation of probation, we do not need to provide a rule, because they were already served with the violation of probation charge.
Okay. But as long as we get, as long as the thing, as long as the bond is set and not duplicated, that's what we're looking for. Okay.
Thank you.
Yeah, we haven't,
Judge, I understand.
do we need to set it for another VOP hearing?
Well, I don't know.
And it needs to be filed first.
Yeah, I believe so.
So file it and then we'll set it.
Very good, thank you, Judge.
Thank you.
Your Honor.
Yep.
I'm sorry. I think what probation is, I'm gonna help Ms. Sturgeon out here. When officers make a probable cause violation arrest, the probation officer then just files the affidavit in the VOP report. They're not going to submit a warrant for him to be arrested on. So the state will be working under the affidavit and the VOP report that's already been filed. So I don't know that anything else needs to be done by the state.
How about setting a hearing? We need to set a hearing? There's no
Yes, if we
hearing
can set a hearing, I think that'd be helpful.
So you want to set that on a miscellaneous docket in January maybe?
Yes.
January 16th?
Yes, please,
Okay.
Your Honor, thank you.
Thank you, Judge.
Sure. And that would be in the morning, January 16th in the AM.
Thank you, Judge.
Okay, thank you. Okay. Mr. LaPel, I guess you're up. I don't see Mr. Keach. We don't see Mr. Keach is not here yet. Mr. Owens. Sure. We've got a couple no attorneys we can do. Is Brittany Boney here? Boney? State? Oh, you here? Would the state please announce?
Yes, Your Honor. This is State of Florida versus Brittany, I think is it Bonnie?
Bonnie?
Boney? It's Boney. That's 22 CF 1571, Your Honor. Miss Bonnie is here for a violation on possession of a controlled substance. The violation alleged was that she tested positive on a urinalysis. Your Honor, the state's offer, just for her to know, is to modify her probation to convert the remainder of her probation to drug offender probation with a 9 p.m. to 7 a.m. curfew. Your Honor, I don't know if she wants to take that today or if she wants to speak to a lawyer about that.
And you do have the right to have an attorney appointed with this violation, this new charge essentially. Do you wish to have an attorney appointed or?
Yes, sir.
Okay. So the court will appoint the public defender. The court will, I'm going to go ahead and enter a denial
and that'll preserve your rights. And we'll come back in January 16th at 9 a.m.
Sure, I do believe this would be Mr. Medina's case.
Okay. So if you'll try and meet up with your attorney before then and figure out where we're going.
And if she can fill that application
thank
out
you.
before she leaves the courthouse.
You can drop that off before you leave.
All right.
Any questions? So this is basically just like an arraignment today.
All right.
Okay, any questions?
No.
Okay, thank you. Crystal Dubois, if I pronounced that correctly? Having a hard time with names today.
It's Dubois.
Dubois.
Yes, sir.
Would the state announce?
Yes, Your Honor, so this is Crystal Dubois. This is 20 CF 1364, Your Honor. She's here for a violation of probation this morning. Violation alleges that several things were not completed at her 30-day review. The state's offer right now is going to be to revoke and terminate her supervision and incarceration.
So, ma'am, you do have a right, first of all, first order of business, you do have a right to have an attorney appointed in these matters. You can't afford one when they'll be appointed. You want to have an attorney appointed?
Yes, please.
Okay. The court will appoint the public defender.
Thank you.
I'm going to go ahead and enter a denial on your behalf. That'll preserve your rights, give you a chance to talk with your attorney. We'll come back on 1/16, January 16th at 9 a.m. in the morning. In the meantime, meet with your attorney and kind of figure out where you're going.
Yes, sir.
What are your options?
Yes, sir.
Okay, any questions?
No.
Okay, thank you.
Thank you.
And you do need to fill out the application before you leave and
Do I
show it turn it into the clerk's office down.
So just in the front?
Nicholas Gamillion. Would the state announce?
This is case number 23 CF 000519, State versus Nicholas Gamillion. He's here on a violation of probation, alleging a new law violation. The offer is incarceration.
Okay. So, Mr. Gamillion, you do have a right to have an attorney appointed with this violation of probation, which is essentially a new charge. Do you wish to have an attorney appointed, or are you going to hire private counsel?
I'll let one appointed.
Court will appoint the public defender, and as you've heard me say to the other folks, I'm going to enter a denial on your behalf, so you have it. That'll preserve your rights, get a chance to talk to your attorney. In the meantime, we'll come back on 1/16 at 9 a.m. Okay, but meet up with your attorney in the interim, and fill out that form and drop it off before you leave. Mr. Johnson, that's the last one, and then Mr. Harper will do yours. Calvin Johnson. Would the state announce, please?
This is case number 18 CF 000917, State versus Johnson. He's here on a violation of probation. The offer is incarceration.
There's a couple other cases too, aren't there?
Oh, that's correct. We're also here on case number 18 CF 1249 and 20 CF 1621.
So, Mr. Johnson, first of all, you do have a right with these violations of probation to have an attorney appointed. Do you wish to have an attorney appointed?
Yes, sir.
Okay. So the court will appoint a public defender, and you've got to fill out the form before you leave today. I'm going to enter a denial of the violations of probation. It's like a not guilty plea on all of them. So that'll preserve your rights, get a chance to talk to your attorney, come back on
We actually did have a warrant for his arrest, that's what I mean.
1/16 at 9 a.m.
Warrant for my arrest, for what?
I think it's VOP.
And I just burned it out on that VOP. I just burned it out, yeah.
It is.
Yep. For my probation violation, I burned it out on that VOP. That's why I'm
Oh,
here
no, it's a
today.
failure to appear.
Failure to appear when?
It doesn't say on this.
I don't have no failure to appear, sir.
You do. I mean, it's in our system. We're going to serve it.
Can I be my property too now?
Probably.
Yeah.
We'll give it to him if you'll just send it to him.
Okay.
December 4th.
December 4th for a traffic case 23 CT 1458.
Right this way, sir.
Calvin Tyrone Johnson.
1049 Virginia.
Mr. Harper, can we let Mr. Owen go? He's just got one.
I'm trying to see how.
Mr. Owen, you ready?
If I could have a few minutes.
Okay, take your time, Mr. Harper.
This is Sheena Hall, she's in custody.
That's right, you just had one. I should have let you go, I'm sorry.
That's fine, Judge.
Well, you had several.
Not too bad.
The only reason I make you wait is because you got a bunch of them, you know.
No worries, fine. Judge, I'm here.
You're here. We've been here entirely too much this week.
2 more days next week to begin, and then a day off in the docket, or jury review.
Judge, this is Sheena Hall before the court on 21 CF 821. For today, we're going to enter denial. I'd like to bring her back on Monday. The reason I'm asking for a short turnaround like that, Judge, is that the state and I and probation have all talked. I think there might be one particular issue we just need clarification on, but this will be a plea on Monday.
Very good. We'll enter the denial and we'll come back on a docket day on 12/18 for hopefully a plea.
See you then. Thank you, Judge. That's all I have this morning.
Thank you, Mr. Harper. Good day. So, Mr. Gates, or either one of you all can go, but I got Mr. Gates listed first.
Yes, Your Honor, I can do my out of custody, Your Honor, to clear some of the courtroom out.
Okay. Then Mr. Medina will do your out of custodies, then we'll do the.
Thank you, Your Honor.
Your Honor, first I've got, that's out of custody, is going to be Donald Frazier. It should be number 14 on the docket. After Mr. Frazier will be Teresa Gore. Your Honor, this is Mr. Frazier before the court. We're waiting for him to finish his substance abuse course. It sounds like there's been a bit of backup on scheduling the last date, so we can continue without subpoenas to the January miscellaneous date.
Okay. Why don't we go ahead, let's go to the 19th on this one.
Yes, Your Honor.
No, excuse me, January 18th. Got 16th and 18th.
Do we have any paperwork on the next court dates I can write in there for Mr. Frazier? Normally we have the next court date. I want to make sure Mr. Frazier has it written down.
Right.
Make sure I write the right one. Yeah, okay. I will say, Your Honor, I want to make sure I got the right date. I have written the wrong date for Mr. Frazier before.
January 18th.
9 a.m.
9 a.m.
January 18th, 9 a.m.
Okay, thank you. I'm gonna do, hope that, I call him every day, I hope that.
Keep calling, okay? All right, Mr. Frazier. Your Honor, next I've got is going to be Teresa Gore. After Ms. Gore will be Johnny Hill. You know, this is Ms. Gore before the court. We need to continue her VOPs without subpoenas. The state and I are working on a resolution. We just need to find a program for Ms. Gore.
Okay, we'll continue this till 1/18 at 9 a.m. for both cases. And this is 19 CF 862 and 22 CF 2928. 2928.
Thank you, Your Honor. Next I've got is going to be Johnny Hill. After Ms. Hill will be Alicia Irby. Your Honor, Mr. Hill's before the court in violations of probation 18 CF 2511. 21 CF 1083, should be number 18 on the docket.
Correct.
At this time, we can ask the court to enter a denial and continue without subpoenas. I was recently appointed to Mr. Hill's case. The state has mentioned that it's an incarcerative offer, so I'd like some time to review that with him and make decisions on what we want to do moving forward.
Very good. So we'll come back on, we'll enter the denial, we'll continue until January 18th at 9 a.m.
Thank you, Your Honor. This is Ms. Irby before the court. I talked with the state about her case. I need to continue her case without subpoenas. She's got some evidence and some witnesses she would like me to talk to about the violation. So if we can set her for January miscellaneous.
Very good. We'll continue until January 18th at 9 a.m.
Thank you, Your Honor. And that's all the out of custody I have, Your Honor.
Mr. Medina.
Thank you, Your Honor. Haley Bernard, after Ms. Bernard would be Mr. Brent Butcher, Buchter. Ms. Haley Bernard, she was here. I'm sure she's. There are people in the hallway. Okay. Can I get Brent Buchter, please? Yeah, there she is. Just have a seat, ma'am, and I'll get with you in a minute. I'm doing Mr. Buckner. Don't leave, please. She, actually, Your Honor, Miss Bernard is trying to get to her 2 small children. Can I call her? That's probably what she was on the phone. I am so sorry, but she has a 10:30 obligation with children, so I'm sensitive to her exigent circumstances. Steve Medina, I apologize, Your Honor. Steve Medina with Haley Bernard, docket 2322 CF 2083. Your Honor, she needs to complete some substance abuse evaluation treatment classes. My understanding is she had approximately 7 classes left, but she may have to make up some. She had a cesarean section in June of 2023, and that put her really behind in complying with some things. She has a newborn and a 2-year-old. If we could
go out a little bit.
If we could go out a bit, that'll help her try to catch up. She's done some of her stuff.
If it was the middle of February, is that sufficient time?
Yes, sir.
She can make a lot of progress by then, hopefully.
Okay, so why don't we do February 15th at 9 a.m.
Thank you, Your Honor. Okay?
Thank you.
You can make, do you want my card?
I've got it.
All right, thank you. Sorry for that out of order, Your Honor.
No, that's all right.
Mr. Brent Buchter is before the court docket 32, 23 CF 491, and then I guess as part of the deal we had resolved 23 CT 1165, so that's riding along with it.
Correct.
Your Honor, he is working with the public defender's investigator to get his Keaton evaluation complete, and also is interested in Jada House. So he's working on options that would hopefully meet the probation officer recommendation. If we could continue him to probably January miscellaneous VOP, we can probably get some information by then.
Okay, so we'll continue till January 18th,
Okay.
9 a.m.
Thank you. Next, Your Honor, is Christopher Daniels, docket 3722 CF 2935. Mr. Daniels, I know he's here too, Judge. I think people are slipping out, and I apologize. Perillas Leah. Miss Leah Perillas, Your Honor, is docket 45. She's approaching at 21 CF 1074. Your Honor, Ms. Perillas has been accepted by Keaton. It's a major decision because she has a 6-year-old son, 10-year-old son, a very nice young man, and I met him, and she needs to arrange for him. It will be much easier for her to go to Keaton if it's after the holidays, so she's asking to come back perhaps January 18th to take a Keaton deal.
Okay.
Very good. We'll continue this till January 18th at 9 a.m.
Okay? Is that good?
Yes, sir.
Thank you.
Thank you.
Thank you, Your Honor.
Is that it?
Yes, ma'am, you're free to go until
Have a
then.
good day.
Thank you. And I'll find Mr. Daniel. Christopher Daniel is approaching, Your Honor. May I?
You may.
Proceed with him. Docket 3722 CF 2935. Your Honor, Mr. Daniels advises me that he needs a continuance, that he has reestablished contacts with the Batterers Intervention Program. He had major financial problems. He's not homeless at this time.
I actually am.
Oh, you're now homeless again. But Your Honor, he's enrolled in the Batterers Intervention. I think you were expired, right?
Yeah, we reinstated it yesterday.
What? Yeah, but your probation time had run out.
Oh, yes, it's about to be.
Okay.
It's in January.
Your Honor, could we continue him to January 18th for a status?
Yes.
Thank you, sir, appreciate it.
Okay.
We'll continue this till January 18th at 9 a.m. What's that? Sure.
Does anybody else in the gallery believe they have coercion in here today? Are you unrepresented? Okay. You still have Mr. Rousseau, who's unrepresented in the audience?
He's on the afternoon docket.
Oh, is he? Oh, yeah. You want to wait for the afternoon?
Yes.
Are you here to see an inmate, or do you have to?
We'll do that probably.
Miller? Are you represented by me? Is it supposed to be this morning? You may have a name in wrong, but it's not Miller on our docket. You may need to go to Jack Brown in 2B. Thank you.
That's right. Why don't we, before we start bringing out the inmates for the remainder this morning, let's go ahead and take a short break and just get them stretched a little bit, 5-10 minutes, just walk around if we need to do anything.
All right,
please. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. C&C Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview very own Dixie Dan Powell of Powell Injury Law for your recent.
I'm Judge Ketchell. I'm James Owens, and I represent Natalie Belch, who's before the court. It's a VOP, and I'm asking the case be continued. The state attorney and I are trying to work something out.
January 18th, does that work?
Yes, sir.
We'll continue to January 18th at 9 a.m.
Thank you.
Thank you very much. All right.
Is this mine? Thank you.
Ms. Sharpless, I understand one of your arraignments you want to get done?
Yes, Mr. Yes, sir. Mr. Brazil is on the afternoon docket, but he is unrepresented, so he was speaking to me earlier, and I believe it's his intention to plead not guilty today, so if the court would go ahead and
come on
take
forward. So, this is case number 23 CF 2507. Are you intending to get an attorney? Do you?
Public defender preferred, Your Honor, if I need to. This is pretty straightforward. I'm sure that.
Whenever you say that, it always gets me.
Well, no, I say that.
Tell me too.
Yes, sir, and I say that.
It never is.
It's.
But anyway, I understand what you're saying. If you wish to have a public defender, the court will appoint the public defender, and the court will enter a not guilty plea, and we'll come back on 2/12, February 12th for the next pretrial. In the interim, you can meet with your attorney, etc. But you need to fill out. Did they hand you the form?
I believe I have it. Yes, sir.
If you wouldn't mind dropping that off in the clerk's office, fill it out before you leave.
Yes, sir.
So you got to get it. It's got to be approved.
I understand.
Okay. So come back February 12th, 9 a.m.
Thank you, sir.
Okay. Thank you. Okay. Mr. Gates, you want to go, or want Mr. Medina?
I can go, Your Honor. I'm ready on my board.
Okay.
That's fine. We'd like to do the females first, though.
Okay, that's fine. So we do the females, Mr. Gates, is that all right?
Yes, Your Honor.
Oh, he might be lining up all the females. Is Mr. Medina gone for a while?
I have no idea where Mr. Medina is. He's not in the hallway. He may be talking to people.
It's not part of your job description, keeping over Mr. Medina?
He's very busy this morning.
So he has the latter end of the alphabet. So I think there's more people with Taylor and Henrich. Is it just Taylor and Henrich Gates?
It is.
Yeah. Okay.
Your Honor, this is going to be Renee Heinrichs approaching. She is number 19 on my docket in front of the court and 22 CF 2374. Waiting on the state to sign, and then I will ask the approach on it. May I approach on it? You may. It is a misdemeanor violation of probation, so look at the score sheet now.
Okay. Thank you. Would you please announce the agreement?
Yes, Your Honor. Ms. Heinrichs will be admitting the violation before the court in 22 CF 2374. She was previously adjudicated guilty. We're going to revoke and terminate her supervision, sentence to 30 days in the county jail with credit for all time served. Additional credit will start from December the 1st, 2023, when Ms. Heinrichs was arrested on an outstanding Okaloosa County warrant in Walton County. The state has agreed to do so because she's been in constant custody since that arrest in December the 1st. $100 cost of prosecution, $150 public defender fee. Ms. Heinrichs has asked for 24 months after her release to pay those outstanding fees.
Very good. Is that the agreement with the state?
That's correct.
Very good. Ms. Heinrichs, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, so you heard your attorney state the terms of the plea agreement, and those terms are also contained in the written plea agreement that you've signed. I just want to make sure you understand what you've signed. You've had a chance to read it and go over it with your attorney?
Yes, Your Honor, I have.
And you had all your legal questions answered?
Yes, I have.
understand this will be a final resolution of your violation of probation, and, but you are waiving the right to go to a hearing and contest these and have the state prove their case. You believe that's in your best interest to have a final resolution by this plea agreement?
Yes, Your Honor, I do.
Based upon that, the court will accept your plea agreement. You were previously adjudicated guilty of the underlying charges. The court will revoke and terminate probation, which means not have to worry about probation anymore when you get out. But the court is sentencing you to 30 days in the Okaloosa County Jail. You will get credit for all time served, and there will be additional credit. Will start by, as a part of this agreement, from December 1st of 2023, when the defendant, when you were arrested in Walton County on this Okaloosa County warrant. And so the state has agreed to the credit because you've been in permanent custody since that time. You've got the additional fees and costs that you always add on to the top. But you will have 24 months from your release from the county jail in order to pay those before it goes to a lien. Okay. And at that time, it would affect your driver's license. So it gives you a chance to get those paid, whatnot, so it doesn't affect your driver's license.
Yes, Your Honor, thank you.
And Your Honor, I did want to clarify the court that's kind of, I think, misstated. She was picked up on a misdemeanor VOP warrant signed by Judge Schlechter. As far as this case is concerned, she's still out on bond. That's why the state has specifically agreed to give her that credit towards this.
Clarifying that. Okay.
Yes, Your Honor.
Thank you.
30 days to appeal.
Ma'am, you do have 30 days to appeal this.
You're walking into it.
Your Honor, this is going to be Andrea Taylor before the court. If she should be number 22 on the docket.
Correct.
I'd like to bring her back this afternoon. Ms. Taylor had given me some information earlier this week. I provided that to the state attorney's office. They wanted a little bit more than that. So I spoke with Ms. Taylor's sister this morning, who was able to confirm what I was told this morning. I've reached out to the state attorney's office, given them the contact info. I'm hoping if they can confirm the information I provided, we may be able to resolve Ms. Taylor's case this afternoon.
So we'll come back at after arraignment, maybe at 2:30. So we'll do this this afternoon at 2:30.
Yes, Your Honor.
All right. So Ms. Taylor needs to come back this afternoon.
Yes, please.
Do you have Nadal? Mr. Do you have Nadal?
Nadal is my client,
Okay.
sir.
Just check. Thank you. You can
He
disregard
can
it.
be taken at any time. Deputy Bob, we can take him any time that's convenient to the court.
Yeah, we're gonna do Mr. We've got his nails coming out. So 9, 10, and 12. Yeah. And then also.
So we're doing your mails?
Yes, Your Honor. It looks like Mr. Jeremy Gafford is coming out first. He's before the court in 0513, 0514, and 0520. 279. I did attempt to speak with him this morning. I think he was a bit frustrated, and I'm going to kind of let him decide what we do today.
Okay. Sorry, tell me the
Jeremy Gafford.
Okay, got it.
When I looked, number 15 on my docket.
Correct. So, where are we at?
Sir, with all due respect, I'd like to address the court and the state on my behalf.
Say what? So we're here on a violation of probation. He's entered a plea previously. This is the first one.
Yeah,
this is the fourth one.
Yes, Sean.
This is the fourth court date. Okay. I would just like to say this, please.
Hold on. Raise your right hand. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
So help me God.
And you understand that this is being recorded, and as you hear on TV, anything you say can and will be used against you in a court of law. Do you understand all that?
Yes, sir.
Okay, and you're doing this anyway?
On my own free will.
Fire away.
Okay, sir. 20 years ago, I was sentenced to 20 years in prison, mandatory. I served that sentence 240 months. I was released on May 10th. I was released homeless, no family, no friends, nowhere to go. They let me out on Highway 98 at the Shell station. Okay, I didn't know what to do. I didn't even know how to work a phone. Throughout all that, I got myself off the streets, found a place to stay. I had 3 different jobs. My only fault was I was doing drugs. And the only reason I did that, I've never even did drugs before. I was just the people that I was around. I'm in here right now for a dirty urine. I have my life together. I have everything. I don't want to be a criminal no more. I spent 20 years of my life in jail, in prison. I'm not a bad, okay, my past is my past. I don't have no, I just want a chance. I don't feel like I had the opportunity.
So what are you asking?
I'm asking, this is my 4th court date. My lawyer's been telling me for the past 3 months, if I could find a drug program to accept me, then that the state would be on board. Okay, I found the drug program. I did the interview. They told me, if you can get the judge to agree to this, we will come pick you up today. When I see my judge, now the whole story's changed. He says that the state told him he agrees to it, but his boss man is saying prison. I don't understand. I mean, for 3 months now, he's been telling me to find this program. I found the program. The people said they will come get me today. That's all I need is just a little help to not be homeless and not struggling. You know, I didn't even know how to work the phone when I got out of prison. Okay, I'm sorry, but please give me one opportunity. If I will take a reinstatement on 15 years probation with a 6.5-year suspended sentence. I just want a chance. I mean, I have somebody now.
What's the state's position?
Judge, I'm not privy to the conversations that the defendant has had with his attorney. Okay. What I will say is the conversations that I've had with the defense attorney are this. He scores a substantial amount of prison time because he was in jail on 3 robberies with a firearm.
20, no firearm. No firearm.
3 robberies with a weapon.
20 years ago, and I served that.
Let him say it.
He scores a substantial amount of prison time. Now, he violated earlier this year, and we gave him a shot by putting him on community control. He violated a second time. When Mr. Gates and I saw this case come up, I said, if you can find a program, I'll listen to what you have to say and hear you out. I was very non-committal. I didn't say that I would agree to it. I brought that to, they got him into a program. I brought that to my supervisor, and the state's position is that it's not appropriate given the circumstances. So that's where we're at. I at no point ever said that the state would give him a treatment offer in the circumstance. Mr. Gates got him qualified for a program, I believe. I think Mr. Gates can talk to that. The state understood that. The state considered that. The state decided that that's not appropriate here, especially given the fact that we put him back on community control, which there's not much else we can do at this point.
Okay, now, once again, when y'all let me out of prison, y'all let me out homeless. I got a dirty urine and came to jail. You let me out on community control, homeless again. And when I went to the community control, the lady was like, well, do you have an address to give me? She says, you know, you got to stay at home. And I mean, all I could say was, I'm homeless. I'm always at home. You know, I don't know. I just don't know what to do. And and my past is being held against me. I need, these people told me that they will let me come stay there, take the drug programs, take the classes, help me get a job, help me get my medication, everything worked out. I need this opportunity. Prison is not the place for me. I can't make it in there. I mean, look at me. Just look at my head. Look at me. It's prison. It's been rough on me. I don't want to live. I don't want to be that person anymore. I don't want to be in that mentality. I'm begging you, just please give me one chance. If I go out there and mess this up, then by all means, I'll sign anything saying if I go and violate and come back, then there won't be, I'll take the 11 years. I'll take it. I'll sign right for it. I'll agree to that right here on camera where everybody can see it. Just give me a chance.
Okay, I hear what you're saying. So, you want to add anything, Mr. Gates?
Your Honor, and just to clarify, the conversations were never the state would do it.
I understand what the situation is between.
And just so the record's clear, the state, I always said the state was open to it. They're willing to listen to it.
And that's what the state just said.
And even today, it was the same, that they were open and listened. Unfortunately, the state's position was no. I told Mr. Gaffer the options were potential evidentiary hearing or sentencing, but that would be put off. And I know Mr. Gaffer is frustrated by the time it's taken to get it resolved, and I don't know that he really wants to delay again for a potential resolution. And my concern obviously is this court hasn't done a lot of plea and sentence immediately, and so that was the concern I had with Mr. Gaffer, and so that's where I left it. He voiced his frustration. I said, I'll let you come out and you can address the court. I'll go wherever the court wants me to go.
It's been 4 months. I just want a chance.
Stop. No, I got it. I hear
I mean,
it.
I don't know what else to do.
Okay, so here's the deal. First of all, I don't get in the middle of negotiations.
Yes, sir.
The state, basically, what you just heard is that your state attorney took it to his boss. Boss is the one who nixed it. Now, I'm not saying he would have gone along with it, but certainly that's not what happened. He can't control that. It doesn't matter. They're not even here. We can't deal with that. And, you know, as much as you want to do something, I can't force the state to accept that. The one thing that you can do, you want to make these arguments. There's only one content. I'm not suggesting you do this. And I'm certainly not promising you anything. But if you want to basically admit the violations of probation, you can go to a sentence that you can argue all you want to me, and I'll make a call. I'll make a decision. You can make your arguments. I may, I don't know, send you down the road for 10, I don't know, what's the guidelines, minimum guidelines for this?
I can pull it, Judge. Give me one moment.
And just so this is all VOP, so guidelines, while they are the minimum, aren't actually controlling. We don't need it down with the part. The court could always modify and reinstate.
Gotcha. That's important to know.
I had bottom in at 132 months,
Okay.
Which was roughly a little bit more than 10 years.
I have that as well. It's 132.38 months.
So, hey, I understand why you're upset. You're looking at another, you've been in for, 20, and you're looking at another 10. That's great. I understand why you're upset, and make matters worse, dragging it out and making you do. So, that's your call, whether you want to try and do that. And I don't know exactly when the sentencing would be. If you want to go that route and argue with, if you're unwilling to accept any offer, the state has to, and it's not even me, the state has to, not the state, but if you're doing a straight up admission, then nobody can object to that, right, counsel?
No, Your Honor. And I think part of Mr. Greber's other frustration is he had 4 cases in 2005. He was sentenced to essentially 20 years in one case, no DOC in the other 3 cases, with 15 years of probation on that. So essentially he served all the time on one case, and he's got no credit at all, except for maybe 5 or 6 months on these other cases. So to be looking at additional, 10 years incarceration on that, as I told him in probation, and I talked about this, we feel like we kind of let him down on the way out of DOC. I wish we could have done more for him. I've explained either way, I'm good with an evidentiary hearing if that's what he wants.
I'll tell you straight up that often happens, and people that are actively involved in the system. I'm not saying I'm happy about it. You get dumped on the street after that. It's like people don't realize when you dump somebody out on the street, hey, guess what? You're a member of our community. We all suffer when something bad happens to you and or you do something bad, we all suffer. A lot of people don't realize that. It's not like you and I. It's not like us against them. It ain't like that. It's about it's about a community. We have a vested interest in you being in the community and being straight. Anyway.
Do you want a hearing or
So, next.
You want to go ahead and hearing, or do you want to send it?
So this is our last miscellaneous of this year, right? Do we have one next week? Don't we have?
We have one on the 19th, Your Honor.
What do we have on? I'm not going to get myself in trouble if I don't think we really, if you choose to go that route, I'm not pushing you to do it. We can accept the plea today, but I can't promise you when we're going to do the sentencing. That may be a month or, as a matter of fact, I suspect it would.
Judge, may I make a suggestion?
Sure.
We do have our trial cycle coming up. There are several days in the trial cycle at the end of December that I don't think anything's actually going to go to trial. We could do the sentencing hearing on that day.
I'm not available, as I explained to the...
No. I appreciate your
and what I'm just as I said, hearing, sentencing, I've done as much as I can. I've talked with everyone, I've turned over. I know what we need to argue at either, so I'm not concerned with that. I just need Mr. Gafford to decide what he wants.
Yep.
And I will make it a priority to get him back in as soon as I can for either one.
So why don't we do this? Why don't we, we've got a few more, we've got some cases. Why don't you guys talk about it and bring him back this afternoon and try and figure out what he wants to do.
Your Honor, after talking with Mr. Gafford, it sounds like he preferred just to have a hearing because there is the positive, but there were some other allegations, I think, at this point. Obviously, if we change between now...
You want evidentiary hearing?
Yes, Your Honor. And obviously, if that changes between now and then, I'll let the court know. And if we've got it noticed, we can always turn that into a sentencing if we need to.
So if we do want to, said you need to...
Yes, Your Honor.
You need to call Ms. Eileen and get it.
And I will do my best.
Try to add a couple of days.
I will do my best.
Won't be between now and the end of the year, but
I'm a little
we're trying to
confused
add
about
days.
something though. I just want to ask the state, so the drug program, that's not an option?
From there, no. From there, maybe. He can't promise you, but that's the only option.
Is there any way if I plead to this and go to sentencing that we can cap it? I just don't feel like a dirty urine. It should be punishable for 10 more years.
And
you want to negotiate a cap, that's fine, but the one thing, the one thing I was saying to you is that you have the authority to enter an admission and argue all these things the same, but that throws the discretion. If you want to have something set, that's got to be based on a deal between you and he's talking. So you got a very
Will it take 11 years suspended sentence and then taken back on 15 probation?
No, sir.
No. Is there anything that you're willing to do?
Don't negotiate directly with me. Your attorney, believe me,
not today.
Very good negotiator.
So it's either here
and
or
he's going to get you the best deal. He's got deals that he means surprise me.
Mr. Gafford has expressed his desire for a hearing at this point.
Very good. Let's do it. So
we'll
go ahead and schedule it.
Yes, Your Honor.
TBD.
This is Mr. Mr. Glover before the court. We have a plea agreement to be filed in this case. I just need to get the state to sign it.
Oh, he FTA.
Did you, TJ, did you bring down Cooser? Is that one of the inmates?
Yes, Your Honor. Cooster is here, but I don't know who the attorney is.
Keach. He ain't here. Well, can you text Eileen and ask her to call him and just see?
Yes, sir.
Your Honor, I got to write on here real quick, no action on the FDA associated with this case.
Okay.
I did forget that portion as well. Need to get Mr. Glover to sign it. In my haste to have the state sign it, I skipped Mr. Glover, Your Honor.
Message delivered.
Thank you.
May I approach, Your Honor? I do not have a score sheet. It is going to be revoke and terminate. It's my expectation he does not score more than 44, so it will not be down on the motion. And we'll stipulate that that score sheet, the state does file it.
Very good. Would you please announce the agreement?
Yes, Your Honor. Mr. Glover's before the court in a violation of probation at 23 CF 222. He will be admitting the violation. We're going to adjudicate him guilty, revoke and terminate his outstanding probation, sentence to credit for time served, $100 cost of prosecution, $150 public defender fee. Mr. Glover's asked for 24 months to pay those outstanding fees before they're sent to collections. And then I handwrote on there waive cost of supervision, arrearages, and then no action on the FTA associated with this case.
Very good. Mr. Glover, would you raise your right hand? Is the state in agreement?
That's correct.
Mr. Glover, would you raise your right hand? Do you
Yes,
swear
sir.
or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement. You've got them written down in the written plea agreement that you've signed. So I just want to make sure you've gone over it in detail with your attorney.
Yes, sir.
Make sure you asked all your legal questions, make sure you understand the ramifications. The big thing is you're waiving the right to go to a final hearing, and this would be a final adjudication of the violation of probation. Do you understand that?
Yes, sir.
And you believe it's in your best interest to do that?
Yes, sir.
Based upon that, the court will accept your plea. The court will adjudicate you guilty of the underlying charges, revoke and terminate probation. You will get credit for all time served. That's essentially the sentence, credit for time served. There's fees and costs that you'll have 24 months after release to pay before they're sent to collections. Cost of supervision, arrearages, if any, are waived, and there'll be no action on the failure to appear associated with this case.
Thanks, sir.
Thank you.
Yes, sir. I think my last custody is going to be Dusty Jernigan.
Okay.
I think he's 21 on the docket, Your Honor.
Correct.
We actually handled this case yesterday. Unfortunately, due to the late ending of court, the jail did not get notice. He wasn't supposed to come to court today. He's scheduled for Monday. The state and I worked out an agreement. I've told Mr. Jernigan that. I'm just waiting on approval from the Emerald Coast Life Center. The second I can get something showing he's been accepted, we have a plea agreement in place.
Okay, very good.
So if we can bring him back on Monday, which is what he's scheduled for.
Docket day in 12/18 at 9 a.m.
Ready for the rest of the team.
Thank you.
And Your Honor, may the state and I approach?
You may.
Jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch.
Okay. Well, while we're waiting, anybody want to stand and stretch? We've been sitting a lot this week. The probation gets to rotate, so you get different people here. We've been at this all week.
I'll be back here in court 2 times next week, Your Honor.
I guess, though, that it's balanced by the fact that I get to sit in a reasonably comfortable chair. I'm not so sure. I'm not sure that wood bench that you're sitting on all day is very comfortable.
Got to shift around a bit, you know.
Mr. Medina.
Yes, Your Honor.
Call your cases.
Thank you, Your Honor. Email secretary. We'll get some legal advice.
That's all right.
I do, sir.
Chandra Beard.
Okay.
Your Honor, Steve Medina with Chandra Beard. She's docket 2322 CF 2082. The last time Ms. Beard appeared in court, the state was not willing to make an offer for resolving this VOP case because its position was there were anticipated additional charges relating to something. To my knowledge, no new case has been filed, so we're kind of in limbo. I don't know if the state has any additional information.
I'm sorry, I didn't catch that.
I'm sorry, this is Chandra Beard. She's the one with a VOP, and there was a probation officer-related search of a house and alleged contraband found in allegedly her bedroom. So there were going to be additional charges, so the state was not willing to make an offer at this time when she had her last court appearance as Beard. So, Your Honor, we'll probably end up needing to continue it, but we're hoping to get some clarity. So, right now.
What's the state's position at this time?
Your Honor, and I'm not seeing any new offenses filed.
And I can verify, I didn't see anything in benchmark as of this morning. I did not check warrants. But she's in jail.
Right, the state's anticipating charges, so they haven't.
I was.
I mean, I'm not forcing you to make an offer. You're not required to make an offer, but at least
I was
defense needs to be able to know.
Your Honor,
whether
is it possible if we pass this until later in the morning and Mr. Medina and I can talk about this really quickly? if that's when we
Sure.
get it.
That would be good, Your Honor. In fact, we are having court this afternoon in the event that that would be necessary. That could be done as well.
I will.
Oh, you won't be?
I will be in mental health court.
Yes, ma'am. Okay. Thank you, Your Honor. If we could set her aside, hopefully we can get a resolution. Thank you. All right.
JJ, we need to set Chandra Beard aside and come back.
Thank you.
I started later this morning.
Your Honor, Miss Selena Boyd is before the court, docket 2721 CF 557. She came to court yesterday. My understanding was we had continued everything to docket day this coming Monday to give the defendant a chance to think things over. So I think we just need to continue her to docket day this Monday.
Very good. We'll continue to dock day at 9 a.m.
Your Honor, can I speak, please?
Your Honor, it's against my recommendation for her to be addressing the court, so just wanted that on the record. Thank you.
And would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
You understand this being recorded?
Yes.
Anything you say can and will be used against you in the court of law?
Yes.
And your attorney's advising you not to talk?
That's fine.
Very good. Fire
All I
away.
want to say is, I think the office are just too big. I have a 4-year-old daughter without a child, and they're just trying to take my life away from me, and I can't do it. And Stephen Medina can read you every letter. All I have is God and Him working for me. In every letter, all I is go by faith, and I know is nothing is impossible with God, and no weapon formed against me should prosper. And walk by faith and not by sight, and that's what I have to say. Have a blessed day.
Very good. Can't disagree.
She's also on the 130 docket that she doesn't need to come back.
Your Honor, I think we yesterday went ahead and entered not guilty plea as to the new law, so that it's not necessary for enter 2 cases for the afternoon docket. They've already been continued to Monday. Your Honor, this is Miss
Rhonda DeWitt.
Rhonda DeWitt. We have an agreement for her that we had worked out last cycle, Your Honor. I just need to get the paperwork. I could not send it back because courtroom security had its hands full a little bit earlier. But may I just have a moment with her, Your Honor? We have an agreement.
Sure.
Thank you. This is your case number. The same agreement we had. She is signing the agreement that we had previously been over. We went over it last cycle. Thank you. May I approach, Your Honor?
You may.
And this is a felony DOP with a reinstate modifier, so there will not need to be a score sheet, Your Honor.
Okay. Thank you.
And I need to give probation a copy. May I have your indulgence, Your Honor, to give probation a copy?
Sure.
It's real simple, but never hurts to have copies. Thank you. Your Honor, under the agreement that all parties have signed, Ms. Rhonda M. DeWitt would be admitting the violation. And basically, this is a time-served deal, but it's being done in a way that would allow her to not be adjudicated guilty and become a convicted felon. She would be adjudicated guilty on the misdemeanor. So pursuant to this agreement should be admitting the violation, reinstate and modify to add special conditions of concurrent credit for time served, and with probation to automatically terminate upon release, maintain withhold on felony, adjudication of guilt on misdemeanor, $100 VOP fee, $150 public defender fees.
That is the state's agreement, Your Honor.
Very creative, Mr. Medina. Would you raise your right hand, sir? Ma'am, sorry. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Okay. So you heard your attorney state the terms of your plea agreement, and the state's in agreement?
Yes, Your Honor.
And I see you signed the plea agreement with the plea agreement contained in it. Have you gone over with your attorney, made sure you understood?
I have.
This is important, basically, like he said, he summarized it very well by saying it's, basically credit for time served, but he arranged it in a way that there would continue to be a withhold of adjudication on the felony.
Mm-hmm.
There would be an adjudication of guilt on the misdemeanor. Do you understand that?
I do.
Okay. There's additional fees and costs as well.
And
I'm sorry.
I apologize for interrupting, Your Honor. I failed to write that, and I'm sure the state would not object to her having 6 months upon release prior to monetary obligations going to collections.
No, Your Honor, no objection.
Okay. Is that sufficient time, ma'am?
Yes.
Okay.
That's so it won't go against your license right away.
If you pay in that 6 months, but if not, then it triggers a lien, but it also triggers license.
Okay.
That's the big thing. It's difficult to survive around these parts without driving. Not like New York City where you don't need to drive.
That's true.
So you want to go ahead and initial?
That is true.
Just initial. I just wrote, she's initialing besides 6 months to pay monetary upon release.
Okay. Very good.
Thank you.
Okay, thank you. So, any questions, Mr. Witt?
No, sir.
Okay, thank you very much. And you do, even though you just entered this, you got 30 days to appeal. Okay.
Christopher Bobbins.
All right, guys, we're ready to go back.
Your Honor, Steve Medina with Christopher Bobbin. It's Bobbin singular, right? Right.
Yes, sir.
Thank you. Your Honor, he's docket number 25, cases 21 CF 152, 21 CF 917, 21 CF 993, 23 CF 657, and 23 CF 667. Your Honor, we are waiting for the evaluation to be completed by, I believe it's Dr. McDonald who's doing an evaluation. He has been accepted to Keaton. He's also been recently accepted to Emerald Coast Life Center, as well as I think he was trying to get into Master's Touch, and I think they would also accept him.
They accept him as well.
But at this time, I mean, it would be great if the state would accept one of those options, but the state had previously said it was not prepared to do any of those options. He can't do a bars to bed Keaton or Emerald Coast.
Discuss him playing to the bench.
Yes, right, and that's, so this, I would ask the state to hold off that opportunity again to plead to the bench pending the receipt of Dr. McDonald's report. We should be getting it very soon, so.
I will, Judge, I think it's good to continue this to look
We'll
at
just
Dr.
continue until next month. Is that sufficient time?
That would be hopefully enough time, Your Honor. I know it's been a while, but Dr. McDonald has been working hard on it.
So we'll continue until the 18th of January.
It was Dr. McDonald.
9
Yes, sir.
a.m. in the morning.
Thank you, Your Honor.
Good luck. Thank you.
Okay.
Spencer Bodiford.
Yeah, thank you.
Tristan Bodiford.
Thank you. Your Honor, Steve Medina for Spencer Bodiford, docket 26, case 20 CF 1516 and 20 CF 1517. My understanding is that the state was not willing to do 11 months, 29 days jail, which he had preferred to do. The state had suggested a plea to the bench with 12.1 months as a cap. on DOC. I had prepared that, and the last time the defendant was in court, he did not want to do that. And may I have just a moment? Your Honor, given that the defendant still maintains that he's unwilling to enter, he's just not interested in the state's options for negotiated resolution, the state may be seeking a VOP evidentiary hearing.
So what are we doing here today? I filed a motion to conflict counsel. Also.
Your Honor, he's indicating he doesn't want the public defender to represent him because of some sort of conflict. I'm not sure what he's referring to. I can't address that.
Has it been filed?
Yes. Not by me.
I filed it and got a response from the court. What was the response? It was just a notification that y'all got the motion.
Your Honor,
when they get filed, a lot of people think they automatically come across the judge's desk. It doesn't.
Right, Your Honor. I'm not aware of any conflict that required the public defender to withdraw. So if he is making a pro se motion to,
is the nature of your motion? You think there's a conflict?
I've been asking for a couple of different things and nothing's happened.
Or is it that you don't feel like you're getting adequate representation?
Yes, sir.
Is that the nature of your filing?
Yes, sir.
Okay. So that's called a Nelson hearing. So that needs to be scheduled.
Would we need to specially set that, or can we do that on a 9/8?
We can do a Nelson hearing.
Okay. So that basically the existing motion that he's referenced that related to allegedly a conflict related would be construed as a Nelson hearing motion and could be set on a miscellaneous. Could we do it January 18th?
Okay. Next month's miscellaneous document.
In the meantime, the public defender won't be taking any further action on this case pending the disposition of that. Thank you. I'm sorry, ma'am?
She just tracked the VOP on that date.
Yes, ma'am. Thank you, Your Honor.
Bradshaw? Malik Bradshaw?
Your Honor, Steve Medina with Malik Bradshaw. Docket 28, case 21 CF 2374. Does the state have an offer at this time in Mr. Bradshaw's case?
And just FYI, I know you all are aware of this, but it may be the basis of the violation, but there's a new law charge that he is coming in for arraignment this afternoon.
Right, Your Honor, that is docket, that's the afternoon, number 6, docket entry number 6, 23 CF 1031. And
is that the basis of the violation?
I believe so.
Okay.
Your Honor, I just wanted to see if the state did have an offer,
sure.
But otherwise we can obviously enter a denial and go ahead and enter a plea of not guilty. But just
not that I can bring up right this second, Mr. Medina. So.
Your Honor, at this point in time,
what did you say, Ms. Sharps? I didn't hear that.
Not that I can bring up right this.
You don't have anything. Okay.
Right.
So the court will enter. You entering a not guilty plea on the new law charge?
Yes, that's for this afternoon, Your Honor. We can go ahead and waive arraignment and issue entry of not guilty on that and deny the VOP in 21 CF 2374 as well.
Okay.
And if we could move him to a VOP non-evidentiary hearing date for status, or would it be? I guess the pretrial for the new law would probably be February 14th.
Well, yes, we would if
that probably makes the most sense,
yeah.
February 14th.
So we'll continue the VOP to that date as well.
Thank you.
They'll run track together.
And then once we get the state's discovery package and so forth, we'll be in to see him and go from there, Your Honor. That'll, I'm sure, include an offer and score sheet. Thank you.
Okay. Okay.
David Branch. Your Honor, David Branch is before the court docket 2922 CF 2053. My assistant is working on a VOP evidentiary hearing date. We don't have that set, but that was a to be determined, and this was a status. Unfortunately, we don't have it set yet, but I know everybody's working on it.
So evidentiary hearing, TBD.
Yes, Your Honor.
And that's based on getting that. Okay, very good.
I'm now supposed to state.
Talk to your attorney.
Your Honor, he's had a major loss of his mother passing away. Was it November 28th, sir? And so he's very upset about that. I understand and have my condolences. I'm asking for a VOP evidentiary hearing. He indicated there was a message he wanted me to give to the state, so I'm just asking him if that's something he wants me to relay. I don't think he needs to address the court. He's asking to approach the state, and that's I don't think that's permitted.
If you want to say something to the state, you're welcome to say it.
So when I came in here,
And again, this is without my recommendation because it's on the records.
Would you raise your right hand?
Yes, sir.
Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
You understand we're being recorded?
Yes, sir.
Anything you say can and will be used against you in the court of law.
Yes, sir.
Your attorneys advise you not to talk,
Yes, sir.
but you still want to.
Yes, sir. Your Honor, when I came in on this case, it was for trying to kill myself because of my late wife. I was going through grief about this. My first offer by the state last time I was here was a year probation. I didn't take that. I went to pretrial conference. I took 2 years probation. This is my first time technical violation. I was released in February, poverty stricken. I couldn't make my payments. That's why I'm here. I don't know why we can't reach a resolution on the case. If it pleases the court, I don't see why 12 months CC is out of the question here. People come in here all the time with 3 violations. This is my first time. I have my stuff in order, but my mother just passed away on the 28th. And I just suffered 2 big losses. You know, I mean, I didn't, it's not like I went out there and caught a new law violation or anything like that. I went out there, I couldn't make my probation because I didn't live in this state. I couldn't get my probation transferred to Alabama. My mother's died in Alabama now.
Okay. So let me explain. I know your attorney's explained it, but I'm going to explain it to you again. This is, I'm sure, exactly what your attorney said, but I'm going to tell you again. A plea agreement is an agreement between you and the state.
Yes, sir.
The state doesn't want the agreement, it doesn't happen.
Yes, sir.
If you don't want the agreement, it don't happen. It's an agreement, like any other contract.
Yes,
Got to be, both sides got to do it. You know who's not a party to that contract?
You, sir.
Me.
Yes, sir.
Now,
That's
if you want to argue with me, you want me to make a ruling?
No, sir.
Then you can admit the violation, and we'll go to sentencing, and you can make all your arguments about what I should do. And now it's in the authorities in my camp. But right now, it's not in yours. You know, the state's got their position, and quite frankly, probably what you say isn't going to impact them a lot.
Yes, sir.
So that's the options we have. So.
That's why I was asking to approach the state about it.
Okay. You heard it.
And just for the record, that's why I was suggesting that he not waive his right to a VOP evidentiary hearing, because he may maintain that for financial reasons he wasn't willful. There may be other defenses relating to the violation.
Sure. Absolutely.
So that could, and I know that everybody on the administrative side is seeking a VOP evidentiary date as soon as it can be arranged.
Sure. Okay. So,
Unless the state has anything to say that might resolve
any
this.
changes from the state side based upon?
No, Your Honor,
defense's statement?
the state has tried to take into account the situation on the original case. It's just simply unable to do that again, Your Honor. So that's why I asked Mr. Medina to gather what information you need to gather from his client and either plea his client to the bench or would have an evidentiary hearing.
So at this point, it is going to be a evidentiary hearing set to be determined, Your Honor.
Very good.
Thank you.
Thank you, Mr.
It's to be determined. Corey Castillo. Your Honor, Steve Medina with Corey Castillo. Mr. Castillo is before the court in docket 33, 20 CF 2228 and 21 CF 2548. Your Honor, I was wanting to inquire as to the state's position, if it has one at this time, for resolving his violation of probation, then we can go from there.
Not today, Mr.
Your Honor, at this point in time, by the way, the October 2020...
I'm sorry, the state doesn't have an offer?
I can pull it.
Your Honor, in fairness, the PO recommendation of Officer Dixon, October 2023, was period of incarceration if deemed appropriate by the court. He had completed...
So this VOP was just filed in October?
Yes, Your Honor, October 20, and he completed Keaton, and there was an alleged violation subsequent to Keaton. And it can be resolved, but we're not going to do it today. So for purpose of today, I think we need to do a denial, but I don't think we need to continue it very long. If we could bring him back on January 18.
Sure.
And then we can maybe reach a resolution.
Has there been a denial entered? No?
No, Your Honor.
Okay.
That's what we would do right now.
Very good. So the court will enter a denial. We'll come back on January 18th at 9 a.m.
Thank you. Okay.
Israel Chartrand.
Mr. Medina, I've got an out-of-custody Stephen Briley that you passed over, number 31 on the docket.
Mr. Briley does not appear to be present. I will can we hold that open? He was out of custody back in, I think, Louisiana. I want to have my office reach out to him. I wasn't aware he wasn't here, but I did have his file, Judge.
Okay.
Can we put him aside temporarily?
Yes, we'll put him aside. We'll come back this afternoon and we'll deal with it.
Your Honor, Steve Medina for Israel Chartrand, docket 34, 22 CF 2721 and 22 CF 3012. My understanding is that Mr. Chartrand has a new law case set for January 16 plea day, January 16, 2024, 23 CF 2618. I don't think there's been an information entered or discovery provided in that case yet. At this point in time, Mr. Chartrand would enter a denial on the VOPs in 22 CF 2721 and 22 CF 3012.
And then you want to track all these together?
Yes, Your Honor.
And we'll come back. So you said the 16th, so we'll do it.
Yes, can we continue everything to January 16, 2024, 1:30 p.m. plea day?
Yes.
Just one thing to let you know.
And Your Honor, the state is still within the 15-day window for the discovery, so we will be working on that and try to get Mr. Medina that expeditiously.
Yes, ma'am, thank you.
Thank you, Judge Ketchel. I'll see you there.
Brian Cora. Your Honor, Steve Medina with Brian Cora. He's docket number 3523 CF 2361. Your Honor, this is a bond here. You're stipulating the bond? I'm sorry. Okay, good. I think the state is indicating it's willing to stipulate to a signature bond. And we could prepare the appropriate paperwork. Basically, Your Honor, if I...
Just prepare me the paperwork.
Yes, Your Honor. So it would be basically the existing bond amounts would be converted to signature bond.
Okay.
Now, I do note that, Judge, may I amplify a little bit? Sure. At the time of his first appearance, it wrote that there were going to be 2 POCS charges with 1,000 cash or professional times 2. It turns out there's only 1. And as for paraphernalia, it was going to be 3 paraphernalias, so then there was only 1. So I would ask that the signature bond be 1,000 on signature on the POCS and 500 on the single paraphernalia.
That's correct. When the state filed an information, it filed on 1 possession of a controlled substance and 1 paraphernalia. The other possession charge turned out not to be enough for FDLE to test, and the state chose to proceed only on 1 paraphernalia charge.
So there'll be a stipulated bond reduction to a signature bond, 1,000 for the possession of a controlled substance, 500 signature bond for the other.
In Your Honor,
order, and we'll get it done.
Thank you, Your Honor. So based on the entry of the clerk, you'll be able to get let out today unless there's something else holding you.
No, sir.
Okay, thank you. And Your Honor, his next court date, sir, I'm sorry, just wanted to say on the record, February 12th is your next court date. February 12th, 2020. Thank you, Your Honor. 9 a.m., sir. Ma'am? Thank you. Thank you, ma'am. Yes, Your Honor.
Yes, sir, you are. Is this Shane Curry?
Yes, Shane Curry before the court, docket number 3620 CF 2324. Does the state have an offer in Mr. Curry's case, and/or could the state stipulate to the bond? Because we did have a bond hearing.
Bond motion?
Yes, ma'am.
I'm sorry, I didn't see the
Yeah, it's a VOP related matter. Just a second, yes, sir. Thank you.
Sorry, Judge, I was unaware.
Yeah, the bond hearing was, the bond, motion to set bond was November 29, 2023. And basically, he was seeking a signature bond. He lives in Defuniak. He has children who needs him. And the violation of probation was technical in nature. I don't believe there are any new law charges. Don't say anything.
Sorry, Your Honor, hold on just a second.
Just the one thing I wanted to add is I believe that he has a stable residence in Defuniak Springs. Is that
Yes,
correct?
sir. And I'm in the middle of a remodeling job. If I had another 3-4 weeks, I'd be able to take and pay off the restitution to where I'd be off probation before I came back to court. It's just right now we're really struggling. Like, we're about to lose our home and everything. We're 2 months behind on the rent. My kids don't even have Christmas presents yet, man. Like, I'm really, yes, sir.
Your Honor, this time the state's offer is an incarcerative offer, and the state cannot stipulate to a bond. And in addition is some not paying off stuff. There's also failure to report and absconding alleged, Your Honor. So the state's not willing to stipulate to a bond.
Your Honor, can we proceed with a brief bond hearing?
You may.
Thank you. Could Mr. Curry be sworn?
Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir. Absolutely, sir.
Mr. Curry, without getting into the facts of the violation of probation, I want to ask you a few questions about the motion to set bond that I filed on your behalf, okay?
Yes, sir.
Okay. Is it true that you have children that need your support?
Yes, sir. I have 5.
Okay. And we wrote 7, 13, 14, and 18, but actually you have 5 children, is that correct?
Yes, sir.
How many live with you, if any?
5.
Okay. And is the 5th child your child? Okay. And that's your significant, you're married, or you're separate?
Married, sir.
Okay. Our motion said married but separated. Could you explain what the...
we're not separated, sir.
Okay. So that was an inaccuracy.
Yes, sir.
And you indicated you have a job that you're working on. Are you self-employed? What is the nature? Are you a contractor?
I have an LLC in workman's compensation. It's Curry & Evans All-Purpose LLC.
And what kind of work do you do?
I do remodeling right now. It's a tile and a sheetrock tear out.
If you were to get signature bond, how can the court be assured that you would maintain coming to court and compliance with the law? For instance, would you be willing to wear a GPS monitor?
Absolutely.
Could you wear a GPS monitor and do your job?
Absolutely, sir. Absolutely.
Your Honor, I would ask for the court to consider a signature bond. I do want to ask him a final question. Is there anything else, without talking about the facts of your case, you wanted the court to be able to consider given the situation?
Yes, sir. I was asking for a bond, or if there was any way they would consider reinstate even with CC and even an ankle monitor. Between my taxes and finishing up this job I'm in right now, a stipulation of my probation was if I paid off the restitution before, that it would be automatic termination of my probation. So with my taxes and the finishing of this job, I would be able to pay everything off. By the end of January, I could completely be off probation and everything if you'd be willing to go that route. Or I'd even be willing. Yes, sir.
Probation verify what you just said?
I was looking over the defendant's violation of probation. I was reading over the narrative for the absconding. And below the absconding is a new law violation. Officer Schultz had attempted to locate the defendant on multiple occasions. And the last time he actually spoke with him, the defendant was 8/10/23. That was the last phone call Officer Schultz received from him, at which point Officer Schultz proceeded to go to his last known residence and was told that the defendant no longer lived at the residence, according to the violation of probation.
Your Honor, could I address that?
Sure.
Just 2 quick points is that if Mr. Curry were to be released with pretrial services and wearing a GPS monitor, that would not only provide eyes and ears and GPS monitoring for pretrial services, but that he still has a scheduled termination date of 2026. I think it was February 14, 2026. So if he was released, he would need to establish contact. And that could also be part of the conditions of release, that he make sure that he stay in contact with probation. Were you serving your probation in Defuniak. Is that who you reported to?
Yes, sir.
Okay, thank you.
The officer I had.
No, I don't want to talk about
Yes,
that.
sir. I apologize.
There were some issues he alleges with the officer, but we're not going to get into that.
Court set a $5,000 signature bond with the pretrial services condition that he wear an ankle monitor.
And Your Honor, could that be at the lowest permissible rate of
Yes.
$1 per month, per day?
Yes.
Okay. And I will prepare the order, but he can be released then on the clerk's record. Okay?
Mr. Curry, one of the most frustrating things that this court has to deal with are people that get violated from probation because they can't stay in touch with the probation officer. I
Yes,
don't
sir.
care whether it's the probation officer or what the deal is. Stay in touch with your
sir.
probation officer and make contact with them on a regular basis.
I
Or else you'll be back here in Orange, and it's stupid. It's a waste of the taxpayers' money and screws up your entire life.
Sir, I
Okay? Stay
appreciate
in
this
contact.
chance so much, sir. Thank you so
Don't
much.
say that. Do the right thing.
I
That's
will,
what
sir.
that's how you want to thank me.
Like, my children need me. I really, this means the world
Do
to
the
me,
right
sir.
thing.
Thank you.
Steve, address and phone number for probation.
19 Donatello Road, Defuniak Springs, Florida, 32433,
Are we gonna
850-614-2974.
Mr. Medina, are we going to sit an evidentiary hearing?
Your Honor, at this point in time, I would ask to just be put on a January 18 status.
So we'll continue to January 18th at 9 a.m.
Thank you.
How do I go about getting my GPS monitor and everything?
They'll talk to you through probation, or
They'll give it to you at the
pretrial
jail.
services
They
will
give it to
come
me at
do
the jail?
that.
Pretrial service
It
will
will
come and give you the deal.
pretrial
Might not be.
services.
Might not be today.
Thank you. Thank you. And that was the address that we had in our bond motion.
Preston Davis.
Your Honor, Steve Medina with Preston Davis, docket 39, 23 CF 199. I talked to his misdemeanor lawyer this morning who advises that he has a misdemeanor court date coming up in the next few days. That date, I believe, is December 18th. If this court would allow him to go on December 19th, we may be able to resolve this based on the outcome of the misdemeanor court. It's a FTA that's disputed in the misdemeanor court, and I'm cautiously optimistic that the misdemeanor resolution will allow
What
a
do we have on
resolution.
December? How many do we have on December 9th?
In the morning, we have 15 cases.
Okay, we'll continue this until December 19th at 9 a.m.
Okay, thank you.
Okay.
Thank you, Your Honor.
Edgar Doubleday? Yes.
Your Honor, Steve Medina with Edgar Doubleday and Mr. Doubleday's on docket 42 in the morning, BOP 21 CF 2592. He is also on the afternoon docket, docket number 12 for plea day at 23 CF 2448, docket number 12. And at this time, my understanding is that the state might be seeking an evidentiary hearing on the violation of probation. It was a 42-month DOC offer from the state, so I don't think we're going to reach a resolution today. I don't think I have the score sheet on that, but I'm sure the state will be willing to look into that. But basically, we're not going to reach a negotiated plea from what I can tell.
There's charges on my score sheet.
Okay.
So have we entered it?
And by the way, if you're going through these, any ones we come to and we haven't entered denial, make sure you let me know. Sometimes
Does the state want to do a to be determined at VOP evidentiary hearing?
We ready to set the
Or
VOP?
is this just
Yes.
Ms. Giardina's case?
Yes, we'll do that.
Okay. So,
So set evidentiary.
to be determined VOP evidentiary.
Very good.
And we'll go ahead and, if we hadn't already, we'll enter denial in 21 CF 2592. We'll enter not guilty plea to take him off the docket for 23 CF 2448.
And then we'll come back on 214 just with the regular pretrial.
Yes, he'll go
On
on
that.
the 214.
Okay. Very good.
And, Your Honor, as soon as I get a score sheet, I'll provide it to him. He may have questions about some of the prior records.
Very good.
I have a score sheet. Okay.
Thank you. Dykes.
I love you.
So we may have.
Print it out.
Okay. Okay, thank you.
You're welcome.
May I have your indulgence, Your Honor? I just need to write myself a note so I don't forget something.
Very good.
Your Honor, Steve Medina with Nerion M. Dykes, 22 CF 29. It's kind of an unusual situation. I filed a motion for a status conference. Subsequent to my motion for a status conference, my supervisor, Charles Russell, went and met with Mr. Dykes, explained options that were possibly available to Mr. Dykes. I then talked to him further this morning, and Mr. Dykes is requesting that he be allowed to withdraw his plea that was entered. He pled to the bench on November 29, 2023, as set forth in the motion for status conference. I was his lawyer on that. I learned about 2 days later that I had missed a issue relating to a motion to suppress that I have subsequently discussed. I outlined the motion in the motion for status conference. I do need to state on the record that Mr. Russell and myself have advised Mr. Dykes that withdrawing his plea, number one, on the positive side is it's not certain that he would prevail on a motion to suppress where a motion to suppress be filed. It's very clear to me from talking to Ms. Sharpless that the state will vigorously contest it, both on the argument of defendant not having standing and also on the argument of the defendant basically it not being well-founded substantively relating to the alleged delays that were associated with the officer interaction with the driver. So in other words, it's all motions to suppress, even under the best of circumstances, have risks associated with it. So he's taken that risk as well as
Right
that.
now, where we're at is a plea to the bench. Is that what occurred back in November?
Yes, Your Honor. November 29.
He's seeking to withdraw.
He's seeking to withdraw the plea, and I just needed to state one other thing on the record and then he can state what he wants to have happen. But the second thing is I've talked to Ms. Sharpless about would the state, under the circumstance, allow him to pursue a more or less a belated motion to suppress without withdrawing the cap of 24 months that had been allowed, had been agreed to. The state's position is if he were to withdraw his plea, it would no longer be willing to give him a cap. So basically, if he is permitted to withdraw his plea, he's taking the risk not only that he would lose the motion to suppress, but that he could have a worse outcome in terms of any sentencing. There is also, he was also advised that there were 2 additional alleged bases for the violation of probation, and it's by no means a certainty that even if he prevailed on a motion to suppress, knocking out the failure to stay at his approved residence, that the court would deny the violation of probation based on the other 2 grounds. He might convince the court that he wasn't willful and substantial. He might not. So there are at least 3 major risks to his withdrawing the plea, if the court permits that.
So you're telling me he still wants to withdraw the plea?
Mr. Dykes, because I did right now try to do a gut check with itemization of major concerns. He wants to think about it and think about, pray about it and talk to his family. So can we, I hate to clog up the docket, but can we bring him back for December 19th at 9 a.m.?
What's the state's position?
Your Honor, when Mr. Medina and I talked about this, his motion is correct. I was out of the office when he filed it, but as soon as I got back, he did call and discuss this issue with me. The reason that I told Mr. Medina what I told him is that I don't think that a motion to suppress would be substantively valid.
What is the position of the state as it relates to the defendant's motion to withdraw the plea?
The state would oppose that motion.
I just kind of wanted to see what your general position is.
So, Your Honor, it may be that based on further contemplation, that if we can hold the status conference over to December 19th at 9 a.m., I will talk to him one more time and he can make a decision.
Very good. Continue until 12:19 at 9 a.m.
Okay. Thank you.
Nadal?
Yes, sir.
Your Honor, I don't think I have anything further if I may be excused.
You may.
I'll be
See
back
you
at
this
1:30.
afternoon.
Till this afternoon.
Till this afternoon.
Sorry for the delay.
Sean Nadal.
Yes, Your Honor. Steve Medina with Sean Nadal. Docket 44, cases 19 CF 3479, 19 CF 3481, 19 CF 3491, 3481 and 3491. Your Honor, at this time, my understanding is the state might be wanting to set this for a VOP evidentiary hearing. I did not want to recommend to Mr. Nadal that he admit the violation. He may have an argument that it wasn't willful and or substantial, the alleged violation. And so if it could be set as a VOP evidentiary, that would be a to be determined. If we need a control date, that's fine, but we hopefully can get that set up in the next month or two.
Very good. We'll set the evidentiary hearing to be determined. If you'll call my office, we'll get it set.
Yeah, I got it. Yeah. All right, thank you.
Chandra Beard.
Thank you, Your Honor. Thank you.
Oh, yeah. Should be, yes, sir.
Okay.
Recall here, Your Honor.
Yes, sir.
Your Honor, are there any other inmates waiting to be seen, or is this our last one?
This is our last inmate for the morning.
Can we have
Last
a-
inmate, but we've got a couple of other, got Teresa Davis that I've got on.
Yes, Your Honor,
And
Teresa.
also Keontae, did we do Keontae?
Yes, those are both going to be information to the court on people who were not at Okaloosa County Jail, Your Honor. May I advise?
Sure.
On Keandre Daniels, docket number 38, 23 CF 1707. The state was going to advise if he was no longer in federal custody. Does the state have any information, Mr. Lasco?
What's the docket number?
38.
Okay, give me one moment.
Yes, sir. And the other one, while you're looking, could I advise on Teresa Davis?
I have a VOP warrant for Teresa Davis.
Teresa Davis is not listed as being incarcerated.
Yes, my understanding is she was in Santa Rosa County Jail. I don't know if the state has any information that she ever got let out of Santa Rosa County Jail. My understanding is she was still there, but I may have bad information.
What's the state requesting as to Teresa Davis?
Your Honor, I am trying to verify that if she's in Santa Rosa County Jail.
And I didn't check
You can check the Santa Rosa jail?
Yes, I can.
I did not check as of this morning, Your Honor. Mine might be a little bit late, so.
I do have one of the conditions of the VOP is a new arrest, so.
I don't have any information, sir.
In Santa Rosa County, Florida.
Your Honor, it looks like she's still in Santa Rosa County Jail to me, Mr.
So what do we need to do on this?
Can we continue her for status of January 18, Your Honor?
Very good. We'll continue to January 18th at 9 a.m.
Would you have anything on Daniel?
This is the
Daniels?
the robbery of the
Postal worker?
Correct. Judge, the co-defendant was in court the other day, I believe, or I gave an update on a similar case. My understanding is that both this defendant and the co-defendant are in federal custody. We're anticipating a plea. It's supposed to occur this month. I suppose it hasn't yet because the prosecutor has not called me. So I would suggest
We
that
just need to set this out.
I would say it's a new law, February 14.
If the court would remember, what I believe is going to happen here is once he pleads to the federal case, it involves the same charges, it'll fall off the docket.
So do you want to do it in January for a status, or you want to do it in February?
I don't see any.
January would be best. I'd like to just keep my eye on it.
So we'll just continue it to 1/18 at 9 a.m.
Yes, sir. Thank you.
And I'll look for an update. That matches my notes.
And Mr. Daniels, regarding Mr. Daniels?
No, regarding Mr.
Keach.
Quiche,
Okay.
and what was his client's name?
Take them one at a time.
Correct.
Okay, so we're good with Daniels. Daniels, we're continuing it to the 18th.
Correct.
Yes.
Okay. And we'll deal with Ms. Keach's client when, let Mr. Medina finish this.
Yes, Your Honor. Steve Medina, we have recalled and is before the court, Chandra Beard, docket number 23 from the morning, 22 CF 2082. So questions are, is there a way to do a global offer today? If not, does the state have any advice or information as to any new charge or charges and appropriate next court date?
Yes, Your Honor, we can do we can do an offer today, but I do need to speak with Mr. Medina if we can have a brief moment together away from
Okay.
the microphones.
Yes.
While you're doing that, Mr. Lasko, why don't you tell me what's going on with, hold on a second, let me pull that case. Okay, go ahead. So it was a bond hearing.
Yes, Judge, he pled out, I believe, yesterday, and the bond hearing was set in case he didn't want to take the plea offer, but I believe he pled out.
Okay,
So I think it fell off the docket.
very good. Okay, thank you.
Thank you. Judge, I don't believe I have anything else in front of you. May I be excused?
You may.
Thank you.
Your Honor, may I be excused as well?
You may. See you this afternoon.
Yes.
Thank you.
Last but not least.
I'll take it. I'll take it.